Good morning, Professor Nadia. I'm Yee Shin, and today I'll be presenting on the topic of relationship between international law and domestic law. This presentation will examine how the fundamental differences between monist and dualist legal system influence variations in compliance with international agreements. I will also address the challenges each system faces in harmonizing domestic legislation with international commitments and provide recommendations to promote consistency adherence. So, state approaches international law in two main ways, which is monism and dualism. Starting off with explaining what is monist system. In monist system, international law is directly incorporated into domestic law, creating an unfounded legal framework where it often takes precedence under the principle of primacy of international law. Ratifying a treaty automatically makes it part of national law, and customary international law is also treated as domestic law. Judges can apply international law directly, and citizens can invoke it just like they were national law. For instance, in the Netherlands, the Constitution Article 93 and 94 provides that international treaties ratified by the country will form part of the domestic legal order and take precedence over Dutch legislation. However, in monist systems, there are variations. Some states fully incorporate international obligations upon ratifications, while others only apply to self-executing treaties, which is a treaty that's clear and precise enough to directly confer rights and obligations without requiring further legislation, targeting individuals and leaving minimal room for interpretations. For example, although the Netherlands follows the monist approach, it still enacts national legislation to fully implement international obligations when required. For instance, after signing and ratifying the Rome Statute, the Netherlands passed the International Criminal Court Implementations Act 2002 to provide a legal framework for transferring suspects and cooperating with the ICC. In some monist states, international law takes precedence over conflict national rules. However, others like Germany treat treaties as equivalent to domestic legislation, while the principle of lex posteriori derogat priori, which means that later law removes the earlier, applies, giving precedence only to treaties over domestic law and enact before their ratifications. On the other hand, dualism takes the approach that international law and domestic law should be kept clearly separate. The doctrine of incorporations allows customary international law to automatically become part of domestic law without requiring new legislation, as seen in the UK, where customary international law is recognized unless it conflicts with a statute. However, under the doctrine of transformation, treaties must be explicitly enacted into domestic law, such as incorporations of the Rome Statute of the International Criminal Court through the International Criminal Court Act 2001, demonstrating the UK legislative approach to make international obligations enforceable domestically. This approach reflects parliamentary sovereignty and ensures a clear separation between international obligations and domestic enforceability. Different countries adopt varying approaches to the integrations of international law within dualist systems. In contrast, Malaysia strictly follows the doctrine of transformation, requiring both customary international law and treaties to be explicitly incorporated through domestic legislation before they can have legal effects. A notable example in Malaysia ratifications of the Conventions on the Rights of the Children in 1995, which required the enactment of the Child Act 2001 to implement its provision domestically. So, moving on to challenges a monist system face. In monist system, international law is automatically incorporated into domestic law upon ratifications and often takes precedence. As such, international treaties may conflict with existing domestic law, creating uncertainty in their applications. Ambiguity in treaties provision can also possibly lead to inconsistent judicial interpretations. For example, in Germany, international treaties are considered equivalent to legislation under Article 59 sub 2 of the Basic Law for the Federal Republic of Germany. However, if a treaty conflicts with constitutional rights, the German Constitutional Court will prioritize the Constitution. As in the Gogulu case, the European Court of Human Rights ruled that a German custody decision violated the ECHR. However, the German Constitutional Court upheld the domestic decision, asserting the supremacy of German constitutional law over the international treaties. This illustrated that inconsistency and ambiguities in interpretations of international law within monist systems can lead to uncertainty in applying international obligations. There are also issues when domestic law may prevail when national authorities deliberately enact conflicting legislation, as demonstrated in the Schubert case. Here, the Swiss Federal Supreme Court addressed a conflict between a federal decree and pre-existing international treaty with Austria concerning property rights. The court upheld the federal decree, prioritizing domestic law over international treaty based on the legislature's deliberate decision to enact the conflicting domestic law. This established the Schubert practice, allowing domestic law to prevail over international obligations when the legislature intentionally contravenes international law. So, even in monarch system, domestic authorities can undermine international obligations through deliberate legislative action. This creates legal uncertainties, and international law is also being disregarded in this situation. To address the challenges in monarch system, several practical steps can be taken. First, establish clear guidelines within domestic legal systems on how conflicts between international law and domestic legislation, including constitutional principle, should be resolved. This can reduce uncertainty in applications of international obligations. Additionally, measures should be introduced to prevent deliberate legislative action that contradict international commitments to avoid international law being disregarded. For instance, parliamentary oversight mechanism could review proposed law to ensure they are consistent with international obligations, and any conflicting legislation should require detailed justification to explain its necessity. Moving on, practical challenges in monarch systems also arise from the direct incorporations of international law into domestic frameworks, particularly when provisions conflict with local values or require specialized knowledge for effective applications. One significant challenge is the lack of awareness and training among judges and legal practitioners who may struggle to interpret and apply complex international norms, leading to inconsistent judicial decisions and undermining public confidence. Additionally, the public is often not aware of newly incorporated international law, which can limit their ability to exercise rights or comply with obligations derived from this law. This lack of awareness can create gaps in understanding and implementations, further complicating the integration process. Another critical issue is enforcement. Domestic institutions and infrastructures are often unprepared to enforce international law immediately upon its incorporations. Limited institution capacity, administrative delays, and coordination between national and local authorities can delay or obstruct the practical obligations of international commitments. So, training and education for judges and legal practitioners are essential to make sure international law is interpreted consistently and build trust in the legal system. Special programs and partnerships with international organizations can provide valuable knowledge and resources. It is also important to raise public awareness through campaigns so people understand their rights and responsibility under international law. At the same time, enforcement mechanisms need to be strengthened. Governments should invest in better infrastructure, simplify administrative process, and improve coordination between national and local authorities. Partnering with international organizations can also provide technical support needed to improve compliance. These actions can help monarch systems tackle challenges, provide legal clarity, and build public confidence. Moving on to the challenges faced by a dualist system. Dualist systems face several challenges when harmonizing domestic legislation with international commitments due to the requirement that international law must be explicitly enacted into domestic law. A state may choose to incorporate only part of the treaty, it leaves gaps in compliance with international obligations. This often led to criticism from the international community and limit the treaty intended impact. For instance, the UK incorporated several rights from the ECHR into domestic law through the Human Rights Act 1998, but effectively placed a reservations on Article 13, which guarantees the right to an effective remedy for rights violations. The UK argued that assisting domestic remedies was sufficient, though these reservations have been criticized for creating gaps in full implementations of the ECHR. In addition, there's an issue of lack of consistency and ambiguity in obligations to international treaty obligations. Since treaties do not automatically acquire domestic legal status without formal incorporations, their influence is applied on a case-by-case basis, leading to ambiguity in enforcement. As seen in the UK case of Smith and another, the Convention on the Right of the Children was used persuasively to interpret domestic legislation in alignment with international obligations. The judge ruled that even without incorporations into domestic law, domestic legislation should be interpreted where possible to align with international obligations. The issue here is reliance on judicial discretion to determine whether how to apply treaty provisions will create uncertainty. As different judges may interpret the persuasive value of international treaties differently, results in inconsistent obligations and undermine the predictability of legal outcomes. Also, when international law is not incorporated into domestic law but applied by courts, even as persuasive authority, it creates ambiguity. This highlights the challenges of ensuring uniform adherence to international commitments in dualist system without full legislative incorporation. Furthermore, when countries apply the doctrine of transformation to customary international law, significant challenges arise, adding extra complexity to harmonizing domestic legislation with international commitments due to the need of explicit legislative or judicial actions to make this norm enforceable. For example, Malaysian courts were always reluctant to apply customary international law as statutory supremacy was prioritized as exemplified in the case of PP and Noron Sopravit. In the case of PP and Wa'aji, also illustrated that it is not the duty of judge or magistrate to consider whether domestic law contradicts with international law, as they were bound to apply domestic statute. To address the challenges faced by dualist system and aligning domestic law with international commitments, several key improvements are necessary. Firstly, when making reservations to international treaties, states should provide valid and transparent justifications. This ensures that reservations are aligned with legitimate domestic concerns while minimizing the risk of undermining the treaty purpose or creating gaps in compliance. Furthermore, to prevent inconsistent applications by judges when international law is only persuasive in nature and not incorporated into domestic law, clear and uniform guidelines should be provided to ensure consistency interpretations of domestic law in line with international obligations. Full incorporations of treaty into domestic law should be encouraged to reduce dependence on persuasive authorities. Additionally, panels or committees could be established to review significant cases involving international law that are not incorporated in domestic law, ensuring consistency in judicial interpretations. Customary international law should be encouraged through the doctrine of incorporation to prevent undermining international law, as firmly established rules of customary international law accepted by most states are essential for conducting relations between states and should be regarded as part of domestic law, provided they do not conflict with national statutes or public policy. Also, delayed implementations can occur when the process of transforming international commitments into domestic legislation is hindered by legislative bottlenecks or political delays. This lag undermines the effectiveness of international treaties and increases the risk of non-compliance. For example, in Malaysia, although the country ratified the Convention on the Rights of the Children in 1995, key provisions were only implemented through the Child Act 2001, resulting in 6-year enforcement gap. This impact of such delays includes political resistance or lack of legislative priority, which can significantly hinder timely implementations. The recommendations to address this issue would be the legislative process needs to be faster and more efficient, with clearer deadlines and incorporating international treaties to avoid unnecessary delays. In conclusion, while monist and dualist systems adopt fundamental different approaches to integrating international law, each encounters unique challenges in aligning domestic frameworks with international commitments. Monist systems, with their automatic incorporations of international law, face issues as conflicting norms, ambiguity in interpretations, and enforcement gaps. Dualist systems, by requiring explicit legislative actions, encounter delays, selective incorporations, and inconsistency in applications. Despite these challenges, the fulfillment of international obligations remains paramount, and it reflects a state commitment to the global legal order. At the same time, the sovereignty of nations must not be disregarded, necessitating a careful balance between adhering to international norms and preserving domestic autonomy. By addressing this challenge with tailored reforms, both systems can achieve a more harmonious integration of international and domestic law while respecting the principle of sovereignty. That's all for my presentations. Thank you. The following slides will be the bibliography.